So good afternoon, everyone. I'm Atrey Mukherjee, Senior Corporate Counsel with Tata Industries Limited and Co-Chairman of the Legal Affairs and IPR Committee of Bombay Chamber. And it is my immense pleasure today to welcome you to the webinar on SEBI Prevention of Insider Trading Regulations and Structured Digital Database, Some Practical Challenges. I would like to express my sincere gratitude to Mr. Bharat Vasani, Partner Cyril Amarchand Mangaldas, and Chairman of the Legal Affairs and IPR Committee, and Ms. Rutu Gandhi, Partner Cyril Amarchand Mangaldas, for addressing our members on the subject of insider trading, an area of regulation which is critical for development and maintenance of fair markets in any jurisdiction. With the spate of regulatory and judicial developments in this area of late, it has become imperative for legal and compliance professionals to understand the emerging landscape of this area. Today's deliberations will cover issues related to identification of UPSI, trading while in possession of UPSI, legitimate purpose, PIT, code of conduct, designated persons, trading window clearance, pre-clearance, institutional mechanism for prevention of insider trading, duties of board of directors, and other related issues. The session will also discuss some of the latest judicial pronouncements on the insider trading regulations. I would also like to take this opportunity to thank our sponsors, BASF India Limited, for their valuable partnership for this webinar, and we look forward to their continued support. To mention a few words about the Bombay Chamber, established in 1836, Bombay Chamber of Commerce and Industry is India's oldest industry association and has a long and illustrious history of continuous service to trade and industry. The Chamber represents a wide spectrum of highly reputed and professionally run companies which are based in the city of Bombay, but whose manufacturing facilities and commercial influence spread through the state of Maharashtra, across India, and also internationally. The Chamber acts as a bridge between civil society, government, and its member organization and aims to promote the interest of all these stakeholders in the overall interest of the country. Although Mr. Vasani needs no introduction, being widely recognized as one of the foremost experts in the country on corporate law, but I would like to take this opportunity to formally introduce him and Ms. Rutu Gandhi to our delegates today. Mr. Bharat Vasani is a corporate partner at Cyril Amarchand Mangaldas, Mumbai's office. Prior to joining Cyril Amarchand, Mr. Vasani was legal advisor to Tata Group Chairman, having also in his earlier role been the Chief Legal and Group General Counsel of Tata Sons Limited, the holding company of Tata Group. Mr. Vasani has over 35 years of experience at senior management level and has successfully built and managed the in-house legal departments of large multinationals. He has been at the helm of and steered several large key M&A transactions pursued by the Tata Group during his 17-year-long stint. Mr. Vasani is highly regarded in government circles and in various industry organizations for his proactive approach on public policy issues. His areas of specialization includes company law, corporate and commercial laws, securities law, capital market, mergers and acquisitions, joint ventures, competition law, employment law, and property matters. Ms. Rutu Gandhi, Partner Cyril Amarchand Mangaldas, has about 11 years of experience in the securities law space, and her areas of expertise include advising on financial services regulation, regulatory aspects arising from capital market transactions, regulatory inquiries, representations, and internal investigations, ongoing compliances, and enforcement. Rutu has extensive experience in advising domestic and global financial institutions and securities market intermediaries on a host of regulatory and securities law matters, such as licensing and registration, ongoing compliances, transactional advisory on regulatory aspects, governance, insider trading and market manipulation, collaborations, cross-border marketing, internal controls, and risk assessment. She also focuses on securities law enforcement and has significant experience in advising on contentious and pre-contentious issues. Rutu routinely advises and represents clients in enforcement and disciplinary proceedings before the SEBI, RBI, and other regulators, and also represents them at appellate forums such as the Securities Appellate Tribunal. So welcome, Mr. Vasani and Ms. Gandhi. Over to you.
Thank you. Thank you.
Thank you. So thank you, Atrey, for your very generous introduction as always. And thank you, Rutu, for agreeing to speak. On behalf of, as a chairman of the Legal Affairs Committee of Bombay Chamber, I warmly welcome you and welcome all the delegates here. This is the most important topic according to me, because any even unconscious infraction of insider trading law has a both huge financial and reputational risk for the company and its top officials. And my experience tells me that over the last few years, SEBI has become extremely enforcement focused. SEBI, which is the regulator for these regulations, has become very, very enforcement focused. And I think this needs to be noted very clearly. They have very little tolerance for any violation of this law, because they believe that, every shareholder and minority shareholder has to be treated with equality. And those who are in possession of a unpublished price sensitive information trade on the basis of that information and make more money compared to the normal shareholder, then that's unacceptable for a fair play or fair market conduct. And as a result, these regulations, which originally came on the statute book in 1992, went through multiple rounds of amendments, including one major one in 2002, were ultimately completely replaced by a new set of regulations in 2015, basis the recommendation of what is now popularly called Justice Sodhi Committee report, which had illustrious people as members like Senior Counsel Darius Kambata and others. So it was a very eminent committee which had made a very detailed report, and the new 2015 regulations were framed. But SEBI has been constantly monitoring the progress of this, and as a result, even the 2015 regulations have gone through so many amendments. First came with the Kotak Committee in 2018, which suggested how do you share the information with controlling shareholders, and some recommendations, some of which were not accepted by SEBI. Even Sodhi Committee's report, though not all the recommendations were accepted. But the interesting part of Sodhi's recommendation was that for the first time, they introduced this concept of bringing legislative notes below each regulation so that you get to know what is the legislative intent behind each provision, which is a very salutary provision. In fact, Sodhi Committee recommended that in future, all delegated legislation and all primary legislation also needs to have this legislative intent clause. Unfortunately, that has not been followed thereafter, but this regulation has a very detailed. So we have below each regulation, there is a legislative note which gives the legislative intent behind the provision, and which Rutu will deal with it. After this, there was a Fair Market Conduct Committee, which was headed by former Law Secretary, Mr. T.K. Viswanathan. And that also recommended certain changes to the PIT regulations. Then these regulations were amended virtually every year from 2020. And every year, there's not a single year. And in some year, there are multiple amendments. So these regulations have gone through by a large number of changes because of the fact that the SEBI is very keen that this law is enforced with absolute strictness and nobody. In fact, SEBI has been asking Government of India for last so many years that, like the US SEC, they need to have power to wiretap the phone conversations of the key managerial persons and CFOs and CEOs during those period. And somehow Government of India has so far not given SEBI the power to wiretap. They can only get the details, the cold data records from the telecom companies. But abroad, as you know, that Rajat Gupta's case, famous case, was entirely based on the transcripts of the wiretap conversation which he had with various people. So eventually, I have no doubt in my mind that SEBI will get that power. I believe SEBI may get that power to wiretap the phone conversations. The other interesting part which I want to tell you, that apart from this series of amendments which have happened since these regulations are brought into force in 2015, there are some landmark Supreme Court judgments which have come in the last few months on this subject, clarifying the law on the subject, in some cases little bit of fundamental shift in the approach. And Rutu will deal with those cases which have come recently from Supreme Court of India directly, apart from side judgments. Then I want to deal with some of the aspects which are very interesting. The people say, what is the origin of SEBI PIT regulation? It's not the 1992 regulation, not the Sodhi report. It is the Constitution of India, Schedule 3. And I want to read out from something from Schedule 3 of the Constitution. Right from Prime Minister Narendra Modi to every minister which takes an oath when they become minister, they have to swear, I so-and-so solemnly affirm that I will not directly or indirectly communicate or reveal to any person or persons any matter which shall be brought to under my consideration or shall become known to me as minister for the union, except as may be required for the due discharge of my duties. This is clearly the language of Regulation 3.1, Rutu. of legitimate purpose. So even minister can share the information only for legitimate purpose, which is what is permissible under the PIT regulations. So the Constitution of India already has envisaged PIT regulations way back in 1950 when this Constitution was adopted, and this provision has not undergone any change. The provision is so important that even the Companies Act 2013 had Section 195 dealing with insider trading, and so there was a view for until this Section 195 was repealed in 2017. Everybody felt that the insider trading provisions are also applicable to unlisted companies because Companies Act applies both to listed and unlisted companies. And a lot of legal opinions were issued by various law firms. How do you implement insider trading regulations in unlisted companies? So I was member of that committee which recommended deletion of Section 195. And I do recall having argued almost for 1 hour before that committee that there's absolutely no justification for Section 195 to be there on the statute book because this essentially falls in the SEBI's domain, and Companies Act should not legislate something which is clearly falling under SEBI's domain. But I also want to point out that even today, Companies Act has Section 166(4), which deals with conflict of interest. And clearly, Rutu, this is the aspect which is touched upon SEBI PIT regulations. Section 166, which deals with fiduciary duties of directors, and Section 166(4), which deals with avoidance of conflict of interest, clearly is a legislative enactment of the insider trading principle into the Companies Act. Now I'm coming to the fact that what we, Rutu and I, get constantly bothered by clients, and we have a challenge. See, what surprises us is that many times clients approach us and say that, please, this is the information which is there, and will you tell us whether this is UPSI or not an UPSI? UPSI, unpublished price sensitive information, is a very fact-specific determination. No lawyer of repute would ever give a legal opinion which says this is UPSI and this is not an UPSI. It is a determination which will have to be made by the compliance officer and the company management. We can only provide you guiding principles for determining whether you should treat this as a UPSI. Same applies to legitimate purpose. Legitimate purpose, as you know, SEBI has chosen not to define it. SEBI has left it to the board of directors of listed company to lay down what should be regarded as legitimate purpose for that company. There is no jurisprudence as of date today in India, either from Supreme Court or any other judicial forum, on what exactly is the scope and ambit of the word legitimate purpose. There is some jurisprudence in the US and UK, but not very relevant to our case in point. There is this whole subject of corporate purpose, which SAT, Securities Appellate Tribunal, had laid down in Rakesh Agarwal case way back in almost two decades ago. But that corporate purpose and legitimate purpose are more or less aligned, but there's a larger doctrine which is there. And we as law firms or lawyers can only give you guiding principles. We can't define specifically. I also want to point out that this Rutu will specifically deal with, I'm going to stop shortly and then allow Rutu to do a PowerPoint presentation where I'll chip in where necessary. But what is important is that this entire concept of structured digital database, which was introduced in 2020 amendment by introducing regulation 3.5, has created a lot of practical challenges for corporates, who are required to comply with this provision. And the level of compliance, degree of compliance has significantly increased. SEBI, and in fact, some FAQs have come out from NSE and BSE and all that, but it doesn't adequately address all the issues. Even today, there are practical challenges in complying with structured digital database provisions of the SEBI PIT regulations. I'm sure Rutu will deal with it, and we will deal with in the question answer session. The most important part which I want to deal with is that this audit committee of the board has been made responsible for, that people can reach out to the chairman of the audit committee under the code of conduct section. So audit committee, which was already, in my opinion, very overburdened with various burden under the Companies Act in terms of related party transactions and other issues, approval of quarterly results, have been given this additional responsibility under SEBI PIT regulations to deal with these complaints and deal with the code of conduct. And now my request to you is that since it's a webinar format, I know you may have a burning question, but since there are more than 100 participants here and it may be difficult for Rutu and me to look at a live look at every question, we will take questions at the end. Please, we'll try to answer as many questions as we can. Rutu has prepared a fairly comprehensive, detailed presentation, which she will now take you through. It's an extremely important subject, extremely relevant today, because the way some of the recent orders have been passed in case of large corporates, which are very, very relevant. We will touch base upon those issues. All I want to say is that this law is in a continuous state of flux. I wouldn't say that there are no more amendments will come. Maybe 2023 will see some more amendments. SEBI is amending the law as and when it gets some new experience in terms of what has happened. And SEBI also comes out with a lot of informal guidances on some of the issues, and HDFC informal guidance on,
portfolio management.
Portfolio managers is also like, so sometimes in fact it lays down a new law by giving informal guidance. So all this will be dealt with. We have a limited time, so Rutu, you can take it over from now. Rutu is a subject matter expert, day in and day out, dealing with the same issue, and so she'll be able to throw more light, and I will chip in wherever required, and we'll collectively answer all the questions. Thank you.
Thank you. Thank you so much, sir. And thank you, everyone, for having us here. I think Mr. Vasani has beautifully set out just why exactly it's important to have focus on the compliances and the practical challenges under this whole insider trading framework. But before I delve into the exact subject matter through the slide deck, I think a couple of things that I want to emphasize on and clarify at the outset is that, of course, we are seeing a phenomenal change in the approach of the regulator in the past few years. And it has to be appreciated as to where the regulator is coming from. You know, SEBI takes its responsibility of protecting the securities market and the interest of the retail investors very, very seriously. If you were to open the SEBI Act, the objective is very, very clear as to what its lookouts are, what its focus on. Obviously, as we see the markets in India develop and mature, we've seen some interesting examples of market manipulation, insider trading, fraudulent and unfair trade practices. And along with the markets having evolved, we are seeing the regulator is also playing catch up. And having seen a lot of these foul plays and misconduct in the market, SEBI has become extremely suspicious and circumspect. So you will see this not only in the realm of enhancement of insider trading framework, but there has been a corresponding effect in terms of which the roles and responsibilities of the board and the management of listed companies are being revisited, being enhanced on an ongoing basis. Like Mr. Vasani was saying, even the insider trading framework themselves have not remained static. It is constantly evolving. And on an ongoing basis, based on its learnings, SEBI is also enhancing not just the compliance functions of the listed companies and the persons connected in the securities market, but also at the same time strengthening its enforcement of that mechanism, right? And this has to be the background that, you know, if as a person you are used to seeing fraud, manipulation, insider trading on a daily basis, which SEBI does see, it's only natural that you would tend to be a little more suspicious in general. So the backdrop of some of the changes, some of the behavioral aspects that we've seen from SEBI in terms of enhancement of measures has this background. And specifically for this reason, while the subject matter is, of course, insider trading, we are also going to be touching upon the very, very relevant aspect of what is your disclosure related conduct insofar as your status as a listed company is concerned. What is the role that the management can play better along with the directors to work with the compliance officer in order to mitigate the risks of insider trading and giving better training to people within the system. So I think with that, I will just run you through the layout of the presentation. Is everyone able to see the screen? Just one
So
moment.
I have not been able to see the screen so far. Can you?
Yeah, I'm just checking. Sorry, we're just going to put that up. Any which way, my colleague is just putting up the screen. I'll just quickly run through the contents of the presentation, how we've structured. Obviously, first we'll be delving into the very important aspect of how does one think about assessing what constitutes this crucial point on unpublished price sensitive information. Then we go about dealing with the protocols of communication of UPSI. When is it permitted? What are the means that are identified? In addition to that, we'll be also touching upon the whole protocols that one has to bear in mind while sharing of information. Some of the restrictions to be borne in mind insofar as trading is concerned, especially for people who may be involved in sensitive transactions, especially who you call the deal team. Then this very, very interesting animal called the structured digital database, and what are the practical challenges insofar as compliance with the specifications laid down by SEBI is concerned. What are some of the calls that the market is taking insofar as ensuring compliance with this structured digital database is concerned? Linked to that, of course, is the guidance that the stock exchanges have provided for compliance with the structured digital database. We will then also be touching upon the roles and responsibilities of the board and management of the company insofar as this entire insider trading framework is concerned. And thereafter, we'll also specifically deal with the roles and responsibilities of the compliance officer. Post that, we'll also be briefly touching upon some of the aspects which will bring home liability under the insider trading framework. And lastly, we will be touching upon some of the best practices, do's and don'ts, just like a quick ready reckoner sorts to always bear in mind, so that you're always mindful as to what are the aspects and pointers that you should always remember while dealing with sensitive information. I'm sorry, there's bit of a technical glitch and we're fixing that, but I'm going to start conversing. I'm going to
just one Rutu, just 1 second. Can we do one thing? Can we send it to Ganesh, who can then host it from Bombay Chamber side? It may work out.
Sure, sir. I will just do that. 1 second.
Yeah, if you can send it to Ganesh, or I can send it to Ganesh, whichever way you.
No problem, sir. I'll just send it to Mr. Ganesh.
Yeah, Ganesh, if you can upload it, that would be great, because I think there's some technical problem at this side.
Yeah, sure. We will do that.
Is it being uploaded?
Hello, Mr. Ritu, can you send it to me?
Yeah, she's sending it to you.
Yeah, just sending, sir. We're just emailing it to you, Mr. Ganesh.
Apologies for that, but Rutu, in the meantime, if you want to continue with your conversation, you can continue till Ganesh is able to upload it, so that no link is broken. Rutu, you may like to continue the discussion till this uploaded. So
yeah, sir, I'll just do that. So like I was mentioning, insider trading as a concept is linked to the possession or access to any incremental information which is under the Indian framework known as unpublished price sensitive information. And primarily, what is it that is prohibited under the insider trading regulations? One, of course, trading while in possession of this unpublished price sensitive information. But in addition to that, and equally important to be borne in mind, is that communication or allowing access to UPSI, unless it is otherwise recognized or permitted under law, is also an independent offense under the insider trading framework. Similarly, illegally procuring the information, which is in the nature of unpublished price sensitive information, is also an independent offense under the insider trading framework. Like I was mentioning previously, the regulations are framed in such a way that it casts independent responsibility and liability on the entity in question, which means the listed company in our context, as well as the individuals involved, such as the compliance officer, any designated persons who may be trading, or any insider in the securities market. Now, coming to this whole concept of UPSI is $1 million question, and everyone is keen to understand that is there a finite list which we can refer to and just get comfortable that this information is or is not UPSI. Unfortunately, the way the regulations are drafted, it is defined more as a concept and not as a finite list. However, there are some guiding principles insofar as it says that UPSI is, of course, information that is unpublished, that pertains to a listed company or a to-be listed company and or its securities, which, if it were to be made public, was likely to have a material impact on the price of the securities. The emphasis here is on the likelihood of it having a material impact on the price of the securities, and actual impact is not relevant. I think a lot of times what we've seen is that the way people seek to kind of defend themselves in an insider trading matter or in an investigation or an inquiry is that they want to take a comparable of what the price was before their trades and what the price was after they traded, and kind of use that to demonstrate that, you know, this was not the kind of information which had any impact on the price and accordingly is not price sensitive information. You may come to slide number 4, Mr. Ganesh.
Ganesh, is somebody helping you with the screen? Slide number 4, please.
Anyway, so like I was mentioning that what is set out under the insider trading regulation is a broad definition. Of course, there are illustrative examples of information that is generally construed to be price sensitive information. What are some of these examples? For instance, mergers, demergers, acquisitions, delistings, disposals, expansion of business, and such other transactions. In addition to that, of course, there are the usual ones, which is obviously UPSI, such as information pertaining to financials of the company, any capital raising activities, so on and so forth. But what this tells us is that while these are illustrative examples, SEBI has not set out any bright line test as to when does a piece of information attain price sensitivity and then leaves the realm of either just being a confidential information or information and takes the color of unpublished price sensitive information. And which is why as persons associated with listed company, it has to be an ongoing assessment exercise when you are, of course, undertaking transactions. One could argue that, you know, if you are contemplating a transaction or an acquisition, any exploratory discussions that you may be having as part of your routine business strategy may not necessarily constitute UPSI. But it's important to bear in mind and remember and assess when do you transition from a mere exploratory or preliminary discussion to a more certain kind of discussion, which takes you in the realm of UPSI. Obviously, some of the aspects have evolved based on case law jurisprudence, and we just want to touch upon that. For instance, SEBI has recognized that, let's say you are a company which is routinely in the business of executing orders, then every single order, which is business as usual, may not be in the realm of UPSI. But let's say if it was an order which was not in the ordinary course of the business, or which had a significant effect on the turnover or constituted a significant order vis-a-vis your turnover, then yes, that is something which would not only constitute a mere confidential information, but be more in the realm of UPSI, which is unpublished price sensitive information. And the rationale for that is that this was likely to have a certain level of impact, material impact on the price of the securities of such company. Similarly, if you are a listed company and you have material subsidiaries, it is very possible that some events may be occurring very much at a material unlisted subsidiary level, but which may, by virtue of that subsidiary being so material to you, have an impact on the listed company itself. In such an event, it's possible that events which are pertaining to a subsidiary may be unpublished price sensitive information for the listed company itself. Similarly, any development or aspect which is likely to have an immediate impact on the security or the performance of the company will be treated as UPSI. In fact, an interesting example that we saw insofar as this is concerned is that there was a private sector bank which had proposed to kind of double the number of its branches in the upcoming 4 years. And this was the announcement that it had made at a certain point in time to the market. What happened a couple of months later was that they came up with a revised announcement to clarify that while they will be doubling the branches, that plan to double the branches is going to be crunched to the very next year as opposed to it being spread over 4 years. And while assessing whether that development, that change from A position to a B position constituted unpublished price sensitive information, SEBI answered in the positive. And the rationale was that when that expansion was going to be spread over a period of 4 years, the impact that the P&L of the company was going to take was going to be spread out. But because of the time crunch, that impact was going to be felt in the immediate next year, and that was going to be significant on the profit and loss account of the company, and which is why it was likely to have an immediate impact on the performance of the company. Based on this assessment, it was held that development till the time it was made public constituted unpublished price sensitive information. Now, why is it that I'm delving so much into facts? It's to just emphasize on the point that it is always a fact specific assessment. What constitutes unpublished price sensitive information today may not have constituted UPSI maybe 10 days ago, maybe 10 days later, right? And each development, each fact has to be assessed on its own merit. In fact, the learnings from the whole future retail case showed us that price sensitivity of an information has to be assessed on an ongoing basis. In fact, there too, the argument sought to be taken was that, you know, there were general discussion in the news, in the media regarding the scheme that was likely to be implemented. However, when it came to the whole enforcement standard, what SEBI brought out clearly is that, yes, there may have been generic discussions, but the information that was in possession of the relevant insiders was a little more enhanced, a little better than that of the market at large. So this just goes to show as to how far our regulator is willing to go and what it expects from listed companies as a matter of conduct and insofar as compliance is concerned. Now, you will see that I've emphasized a lot on the conduct of the listed companies and the fact that SEBI is looking at it not just from the lens of insider trading, but also generally from a whole disclosure regime perspective, responsibilities of the board of directors. The reason is also that a while ago, SEBI had kind of delinked the whole concept of UPSI and material information. Earlier, the contemplation was that any information that you disclose under the SEBI LODR regulation to the stock exchanges is deemed to be UPSI, is indicatively price sensitive information. However, post various consultations with the market and deliberations at the committee levels, there was an amendment which was introduced in terms of which UPSI was delinked from material information that is disclosed under the SEBI LODR regulations. SEBI very rightly appreciated that all material information which may be disclosed to the stock exchanges may not necessarily be unpublished price sensitive information. I think it's just important at this point in time for us to be mindful that while insider trading is an independent compliance, SEBI is also on an ongoing basis monitoring your ongoing disclosures and the quality of those disclosures that you're putting out to the stock exchanges. For instance, we've seen that, you know, whenever companies undertake an acquisition, the kind of press releases or the kind of information which is put out as part of the stock exchange disclosure runs into pages and pages. And there is a certain emphasis on how this activity is likely to have a positive impact and synergies of cost and leveraging on capabilities and everything, etc. However, when an investigation is undertaken, insofar as insider trading activities is concerned, the stand that these companies tend to take is that, you know, this acquisition was not material. It was only acquired for, let's say, a 2 crore, but my consolidated profit or my turnover is so many thousands of crores. And, you know, this is just absolutely not a material development for us. I think what the regulator expects, and this is also something which was reinforced based on our recent engagement with SEBI on something, is that they want to see you taking consistent approaches as a listed company. It can't be that from the perspective of you sending out a messages to the market or the shareholders, you are taking a particular stand, but when an investigation takes place, you are taking a completely different stand. I think this was also briefly the issue in the matter of Mr. Ranganathan, in fact, where SEBI specifically looked at the disclosure which was set out as part of the stock exchange intimation, the press release which was made, and in fact the arguments that were sought to be advanced, in fact, that, you know, the cost of acquisition was minuscule compared to the total turnover of the company. None of those points were emphasized of that press release. So while, you know, as compliance function or as the secretarial department, we tend to look at things independently. What the regulator is doing is drawing linkages at every possible points in time about your ongoing disclosures and what are the stands you are taking insofar as investigations is concerned. And I guess if you see some of the proposed amendments to the SEBI listing regulations, the emphasis is on greater involvement by the board and the KMPs, including revisiting some of the disclosure standards where, you know, the flexibility accorded through aspects on which you could come up with a materiality policy is being re-looked at. This whole goes to show as to what are the kind of ongoing updates the regulator expects you to make to the market. And insofar as aspects where you will have the flexibility to kind of set out the materiality thresholds and make disclosures on that basis, from that perspective, SEBI will necessarily treat that information as UPSI. This is also emphasized insofar as several cases that we've seen where, you know, the observation that either a securities appellate tribunal or SEBI itself has made that your board itself decided that this was a material event for the purposes of disclosure based on your materiality policy. And now it's not open to you to argue that this was not material and price sensitive in nature. So I think just an interesting development to be borne in mind that your conduct, ongoing conduct as a listed company or ongoing disclosures will also be equally crucial insofar as your compliance with insider trading framework is concerned. Now, while we are dealing with all these things, what are the key considerations that one should bear in mind while assessing whether or not information is UPSI or not? First and foremost, what is the nature of the information that you're looking at? Would you treat it as certain, or would you treat it as something which is more speculative in nature? Is it likely to have an immediate impact on the company? Third, is there a likelihood of material impact on the price of its security? And remember, it's the likelihood and not the actual impact. Fourthly, is the probability of transaction going through more than the probability of the transaction not going through? Materiality of information. Please don't only look at information from the standpoint of financial matrix. Sometimes information can attain price sensitive from a strategic perspective as well. For instance, that if you are a company which is engaged in a particular class of business and you're suddenly venturing out into a new class of business, that may also be treated as unpublished price sensitive information from a strategic perspective, not more from a financial perspective. And I think the most basic and other fundamental question that one should ask oneself while assessing this is that, can I, as a person having access to preferential information or incremental information about the company, can I today take a position in the securities of the company and can either make a profit or avoid a loss? If the answer to this is in the positive, then it's a very good indicator that the information that you're dealing with is in the realm of unpublished price sensitive information. Now, we were dealing with the fact that, once you've assessed that, information is price sensitive, automatically there are protocols in place. You have to be very, very careful while dealing with this information. Communication becomes a very, very crucial aspect then. Next slide, we'll be dealing with the whole communication of UPSI. So communication, like I was mentioning previously, is an independent offense under the insider trading framework. But however, of course, like we were mentioning, as the law has advanced, the regulator has also advanced leaps and bounds and has recognized and created avenues for sharing of your information on an ongoing basis. What are some of these avenues that are recognized? Of course, for transactions, that's one. If it results in open offer, SEBI's rationale is that all relevant information to enable the shareholders to make a decision has to be made public through the letter of offer, and which is why this is fine. Insofar as transactions which do not result in an open offer situation, there the expectation is that any UPSI, before it's shared, even for diligence purposes, can be shared only after the board of directors of the company have passed a resolution that such sharing is in the best interest of the company. Secondly, you have executed confidentiality and non-disclosure agreement with the counterparty, and any UPSI that you may have shared kind of needs to get disclosed at least 2 trading days prior to effecting the transaction. There are some interesting practices that the market is following. Some do it through investor presentations. Some people, if they are aware of, more than a few quarters before that a development is likely to take place, they try and find ways to kind of disseminate this information either through their interaction, through regular analyst meets, or ongoing disclosures. In fact, a lot of companies have made their disclosure regime a lot more robust. There are certain companies that, in order to be able to speak about certain developments or certain aspects, even including as part of interactions with analysts as well as investors, come up with certain operational data on an ongoing basis. And they are not literally linked to the financials of the company, but operational data which goes to the heart of determining their performance, and which kind of also enables it to talk about certain things without tainting anybody or precluding their ability to trade in the securities at a given point in time. So of course, the revisiting of disclosure regime, the quality of the disclosures that you put out will also be something that you need to assess on an ongoing basis to be able to cleanse yourself of information on an ongoing basis. Other important and a more nuanced aspect of kind of sharing of information is this concept of legitimate purpose and need to know basis. It's not defined as a finite list or anything, but more as a concept, and recognizes that there may be aspects or initiatives for which information will be required to be shared with certain people, and that is recognized. For instance, the most obvious example is sharing of financial data with your auditors to be able to enable them to carry out their functions and audit the accounts and kind of come up with their independent opinion. But in addition to that, there is also a recognition to be able to share information with your advisors, merchant bankers, and similarly other aspects. There is no finite list, unfortunately. And I think an interesting question that Mr. Vasani and I have grappled with from companies is that, can I routinely share information on an ongoing company with my promoter entity or with our private equity investors? There will always be pressure, and there will always be considerations to balance. But just from a legal perspective, if one were to look at it purely from a legal perspective, and like Mr. Vasani was pointing out, that this proposal, insofar as sharing of information with the promoters, was specifically tabled before the quota committee. And while there were deliberations, there were recommendations that this be allowed, this recommendation was not implemented. So unfortunately, routinely sharing information with promoters or private equity investors is not a recognized purpose that, or an avenue or exception for which UPSI can be shared. What you can do is, of course, see if there is any legitimate purpose that can be established, for the purposes of enabling this sharing of information. Is there any strategic benefit? Are they acting in their capacity as a strategic advisor to help you perform better? And can that be justified to be in the best interest of the company and the public shareholders? Yes, you can actually think about doing it. We have seen some interesting examples evolve in the market where these avenues have been explored and information sharing has taken place pursuant to that. I think some of the examples where you could kind of consider to be in the realm of legitimate purpose is sharing of UPSI in the ordinary course of your business with existing or proposed franchisors, partners, collaborators, distributors, merchant bankers, engaged or appointed by the listed company. Obviously, the rationale being that they are providing certain services to you for which they require this data to be analyzed. Similarly, sharing of information in furtherance of performance of duties, including any corporate or fiduciary duties. For instance, information is routinely placed before the members of the board to help them assess how the company is functioning and if there are any enhancement of measures or any new steps that need to be taken. Similarly, sharing of information with any intermediaries or fiduciaries such as auditors, merchant bankers, consultants, advisors. Similarly, if information is proposed to be shared for any audit purposes, including a forensic audit, that is also capable of being justified as legitimate purpose. Sharing of UPSI, like I was mentioning with the promoter, can also be established so long as there is a legitimate purpose in the background and there is no unfair advantage that is sought to be provided to the promoter, and there is no breach of the regulations taking place. So typically we've seen that there are standstill arrangements which people kind of contemplate from a risk mitigation perspective, where the party receiving the information is consciously made aware that you are receiving inside information, you will be an insider, and any trades that you undertake then will be subject to the applicable law. And if you are deemed to have traded while in possession of unpublished price sensitive information, then you face liability from the securities market regulator. Sharing of UPSI in the absence of a legitimate purpose with private equity investor or any other party will be a tricky proposition. And like you'd be seeing that there is a lot of discussion on an ongoing basis where SEBI has reached out to the top companies to kind of get what SEBI has been doing through the stock exchanges is randomly picking up some of the stock exchange intimations that the companies have made. And I've asked them a very, very pointed question that, you made this disclosure. Was this UPSI? If yes, please tell us if corresponding entries have been made in your structured digital database. If this was not UPSI, then please tell us your rationale for not treating it as UPSI. And I think through those questions, what is sought to be assessed and demonstrated is that who had access to information at what point in time, and was that access really necessary? So I think just some of these important points to be borne in mind. Structured digital database, of course, is a subject that we'll come to in detail a little bit later. But coming first and foremost now to protocols that one must bear in mind while sharing of information. First and foremost thing is, of course, the hygiene and maintaining of your structured digital database. While I'll be coming to that a little later, but very, very quickly, the kind of information that one has to maintain is the details of the person sharing the information on behalf of the listed company, the natural person receiving the information on the other side. And if it is, if that person is representing an organization, then the details of the organization along with their legal identifiers. And every time there is an update, the expectation is that an updated entry will be made in the structured digital database. Some of the other important practices that one should bear in mind insofar as sharing of UPSI is concerned, that at the outset, if you are knowing that you are in a deal mode, you come up with certain do's and don'ts that the deal team should adhere to. Specifically that you try and keep it a very, very close-knit group. The principle that you have to follow even within that group is strictly need to know basis. So it's possible that every member of the deal team may not have access to the same kind of information. Obviously, if it's a common work group, try and ensure that only those people who are required to have access to this work group are made party to that work group. In a lot of instances, we see that unfortunately senior management members are brought in on a particular deal discussion much in advance prior to their involvement actually being required. One is, of course, that the scope of or the number of people that then start having access to information expands, which means that there is a greater risk of leakage. And second implication and consequences of this is, and this is a very real problem, and a lot of queries we receive is that, what do I do if I want to trade? Because I'm always going to be in possession of information. So one of the things that we've seen some of the listed companies do differently is kind of avoid discussions of UPSI at management meetings, so as to avoid tainting them if they are not part of the deal team. Only bring them in or take that proposal to them when their involvement is required to kind of approve a proposal or to approve the deal. If any information is required to be shared outside of the deal team, then of course try and do it solely on a need to know basis. And obviously, if it is falling under the category of a deal which is not resulting in open offer, then ensure that any UPSI which was shared is cleansed appropriately, either through an investor presentation or you would have already done that through ongoing market updates or through discussions with the analyst if it's scheduled during that time. Another aspect we've also seen companies do is that there are very, very strong internal controls and measures insofar as dealing or treatment of UPSI is concerned. A lot of times, information is shared in a lot more democratic and open way within the organization. Obviously, it fosters a spirit of togetherness and kind of, working together for the company. But the danger and the risk it causes is also that there is a greater risk of leakage. And there have been instances, in fact, it's not a listed company situation, but there was an employee in the merchant banking division of an entity who was assisting on a confidential matter. And he was talking on the phone on a client call, and turned out his family members picked up on that information, communicated it to some other family members who ultimately traded. And this person was actually charged with insider trading, resulted in a loss of reputation, loss of employment. And I think Mr. Vasani can also tell you, having witnessed these aspects over so many years, that in most situations, the pain of the process is worse than the outcome. And really, it's very tiresome dealing on an ongoing basis, responding to the regulator's queries and trying to justify that you indeed did not either willingly communicate or did not intend to communicate. You just can't help it if someone overheard you. So it's very important to have these hygiene measures in place, that people who routinely have access to information should be physically segregated from people who don't have access to information. The communication points between these two classes of people should be absolutely restricted. There should be segregation of IT infrastructure, access points and everything, just to ensure that today, if the regulator were to come knocking at your doors, and it's not just enough for you to show that on paper you have these policies, but in practice that they are being implemented. This will kind of help you to ring fence liability at an entity level,
Rutu, can I chip in here for a minute?
Absolutely, sir, please.
I just want to kind of bring out the fact that having worked in multinationals, most of the listed subsidiaries of multinationals operating in India, even companies which are not subsidiaries, but they are listed companies. What I observed is that the parent companies, whether located in US or UK or any other corporate headquarters in Europe, they insist on a very detailed information almost on a fortnightly or a monthly basis from such listed entities, which gives complete details on profitability, product-wise profitability, market share, everything, which is by any standard, some of that information would be regarded as UPSI. Now, obviously, you need to protect yourself to create a legitimate purpose, because as of today, despite the recommendations of the Uday Kotak Committee on Corporate Governance in 2017-18, when they recommended that the controlling shareholder or the promoter, whichever you call it, should be allowed to have access to UPSI, and it is needed for legitimate purpose. And lockbox system, which he had recommended, and the information sharing agreement to be signed between the two, and information shall not be used for trading in securities. Everything, the SEBI did not accept the Uday Kota Committee recommendations, maybe because of Rec 4 of LODR, which says that as far as information share is concerned, whether controlling or non-controlling shareholders, everybody has to be treated at par. But be that as it may, the reality today is that most of the promoters and most of the controlling shareholders, and particularly multinational companies, not through their nominees, independently have access to UPSI of listed companies in India. And if this really is gone into detail by the regulator, you need to have a very robust reasoning to justify your practices. You can't say that it's my parent company and I'm sharing all the details. I am aware of the extent of detailed information which is shared by various Indian subsidiaries of foreign multinationals operating in India in a listed space. So it's a very dangerous game, and one has to be very, very careful that in future, if the regulator were to pounce on you, you have a very solid reasoning. Today, the law does not explicitly allow sharing of information with the controlling shareholder unless it is for legitimate purpose. That's all I wanted to say. Thank you.
No, sir, I think it's a very, very fair discussion right now. And, given the capital infusion that we have, or even the involvement of promoters, for them, it's a very, very natural ask to have access to that information. But just the way our regulations are framed, it's not fair to kind of assume that this is just something, it comes very naturally for us to think that, it's my parent entity. Of course, I have to share information. But if one were to look at it strictly from a legal restriction perspective, like Mr. Vasani was rightly pointed out, unless you have a legitimate purpose, this will be a difficult stand to defend. And like I was mentioning, we have seen companies kind of establish legitimate purpose, and there are kind of very, very sophisticated strategic advisories that are being provided to the listed company, which actually helps it better run its business as legitimate purpose in exchange for the purpose of sharing of information. Similarly, I think linked to this whole hygiene of putting in place these measures, it's equally important that the moment you feel that the initiative is progressing in the right direction, or the deal is attaining price sensitivity, you immediately inform members of the deal team that henceforth you should not trade in the scrip of the company till the time the information is made public. So I guess these are some of the important aspects insofar as protocols for information sharing is concerned. Linked to this whole sharing of UPSI is the restrictions that one has to look at from the perspective of trading. Now, obviously, the way our framework works is that the scope of restriction insofar as trading is concerned is not just buying and selling of securities. Trading is a very, very broad term and is understood to also include trades which are in the nature of pledge of shares. So a lot of times we get asked practical questions that, I'm not really selling, it's just a pledge. I need personal finance. Can I just go ahead and do it? The window is closed. Answer is no. You will have to do a risk assessment, whether you're comfortable going ahead with taking a risk that although the trading window is closed, you are very comfortable that you don't have access to information, which is why you want to go ahead and trade. Why is this risk assessment important? It's because that trading while in possession of UPSI, it doesn't matter whether you intended to rely on that information or not. Those trades would be presumed to have been motivated by the knowledge and awareness of such information or in your possession. So which is why it's very important to bear this in mind. To that extent, it's a very, very strict liability offense, and it doesn't really matter whether you had the intent of kind of breaching the law. Like Mr. Vasani is pointing out, some interesting jurisprudence has evolved on this. And I think before I go on to the whole Supreme Court judgment, the law itself has recognized certain avenues through which you can defend yourself and prove your innocence to show as to why your trades, although they may have been undertaken while you may have been in possession of UPSI, but would not necessarily make you guilty of insider trading. Mr. Vasani briefly touched upon this whole genuine business corporate purpose. I think we've seen some examples in the recent past where people have traded ostensibly while they were in possession of UPSI, but in the best interest of the company, in terms of which, in order to kind of save the company from any bankruptcy situation or any bad financial situation, trades were undertaken while in possession of UPSI. But I think the only differentiating factors there, from a factual perspective, and that kind of helped the case of the insiders, was that all that money, the proceeds of the trades, were infused into the company on an ongoing basis. So SEBI kind of recognized that. So yes, it is that from a insider trading framework perspective, all SEBI has to do is that, yes, you're an insider, B, you had access to information, and then the burden automatically shifts on you. Then the onus rests with you to kind of demonstrate what was the rationale and the objectives of the trades that you have undertaken, and how, in a given set of circumstances, that does not constitute insider trading. In fact, through those judgments, the Securities Appellate Tribunal has also recognized that the defenses that have been outlined for trading while in possession of unpublished price-sensitive information under the PIT regulations are not exhaustive. They are only indicative. And for instance, this particular fact pattern that we dealt with, where trades were undertaken to kind of prevent the company from going bankrupt or going into an adverse situation, was then recognized by the Securities Appellate Tribunal as a rationale for it to not constitute insider trading. So we've seen some interesting jurisprudence on this. But the principle remains that obviously you may have to fight it out to an appellate authority, but really it won't preclude the regulator's ability to kind of charge you with insider trading. I think some of the companies have very, very low risk appetite, and it's important for you to know that any such situation, unless you fight it out, will result in a regulatory proceeding, and which may last over a span of few years. So just some interesting insights to be borne in mind. Linked to this whole aspect of restriction on trading is the identification of the trading window closure period. Several investigations and inquiries have happened at SEBI's end, in terms of which the main question that SEBI would ask compliance officer is that, okay, in terms of our interaction or engagement, you told us that XYZ information is UPSI. Where is this intimation to the stock exchanges notifying a formal closure of trading window? What most companies do is try and link this closure of trading window to the announcement of financial results, so that they don't have to separately call out the closure of the trading window. This is also done before the deal attains certainty and the definitive agreements are signed, so as to avoid speculation in the market. But obviously, this responsibility is cast on the compliance officer to close the trading window upon crystallization of UPSI. Unfortunately, in our experience, what we've seen that even at discussion stage, where the deal was announced much later, the underlying message that we've received from SEBI is that even exploratory or preliminary email exchanges are likely to be treated as UPSI. Again, like, the emphasis would always be that assess the information on an ongoing basis, but once it has attained price sensitivity, then treat it differently and put relevant measures in place. I think important aspect here, insofar as closure of trading window is concerned, I'd just like to bring in the perspective from the whole Reliance Jio Facebook case, in terms of which one of the allegations against the compliance officers was that they failed to close the trading window when the UPSI was in existence. And I think they were successfully able to argue that the requirement to close the trading window comes from Schedule B of the insider trading regulations, in terms of which the expectation is that persons who have access to information will be informed that the information being shared is UPSI, and that for them the trading window is closed. They also very nicely pointed out that there is no separate circular or a regulation under the whole 2015 framework, which requires a separate notification to the stock exchanges insofar as closure of trading window is concerned. This was, of course, emphasized in light of the fact that insofar as financial information is concerned, the closure of trading window is specifically recognized and under the PIT regulations, and which is why that is done. But other than that, so long as the company has implemented its code of conduct in line with what the minimum standards are, and has also informed the relevant members of the deal team, the designated persons or any specially recognized persons who were part of the deal team, that, you know what, this information is UPSI, and from now onwards till the time the information is made public, you and your immediate relatives should not be trading in the script of the company, was treated as closure of trading window. In fact, they were able to successfully defend their stand in that case. This is obviously quite surprising, because the stand that SEBI earlier used to take is that, you know, you're required to formally close the trading window. We are yet to see more examples of this, where this stand is defended again and is upheld. But I guess some of our clients have revisited their policies and code of conducts and internal practices to take in from the learnings of this case and kind of shift the burden from the compliance officer or the company itself to the designated persons once these designated persons are informed that information that is being dealt with is UPSI, and now you are responsible for ensuring that you don't trade while you're in possession of UPSI. Next, we come to the whole linked concept. Oh, I'm sorry, I missed on saying that, you know, when the trading window is closed, come to the next slide. When the trading window is closed, most companies would put a blanket restriction on trading by all designated persons. Important to remember that trading restrictions would also be applicable on any shares that you want to deal in, even upon conversion of ESOPs. Exit from the deal team or resignation from an employment will not automatically result in the trading restrictions to be lifted. The determining point will, of course, be your access to information at a given point in time, and whether or not you could still deem to be a connected person to the listed company for the purposes of your trade. Obviously, every time a transaction is discontinued or, you know, a deal is no longer pursued, the compliance officer will always identify a cooling off period during which, you know, trading activities will be restricted. So important for you to kind of engage with the compliance function, and obviously these are some of the aspects which should be done in consultation with the management and not just be left to the compliance function, because price sensitivity of the information, when to close, when not to close a trading window is some of the aspects that we believe the compliance function alone may not be best suited to take a call on. And it's always like a joint effort and practice by the management to kind of consult with the compliance department to put these restrictions and protocols in place. Limited scenarios for trading during the trading window closure. Obviously, you are entitled to exercise your ESOPs because there is little scope for foul play. Similarly, there are other recognized means that if you are trading because of any legal or regulatory requirement, then that is also an exception. If you want to create a pledge for a bona fide purpose, which you will again have to defend, that has also been recognized. But obviously there are limited scenarios, and that does not take away from the fact that tomorrow the regulator may come knocking at your door and ask you to justify as to why a charge of insider trading should not be brought against you. So these aspects to be borne in mind, and whenever a risk call is taken, you should have justifiable rationale for such risk assessment. Coming now to the whole aspect of structured digital database. I think we briefly touched upon the fact that, you know, SEBI is looking on ways to kind of strengthen its enforcement of the whole insider trading framework. Now, you would have heard from news reports and articles that that evidence in an insider trading case is always a difficult and a vexed issue, and regulators around the world, including in India, struggle with showing direct evidence of a matter. And which is why basically to aid SEBI in its investigations into cases involving insider trading, this concept of structured digital database was introduced, in terms of which listed companies, intermediaries, and fiduciaries are expected to maintain this digital database, in terms of which you will be required to maintain details of the nature of UPSI being shared, the details of the person sharing it, and the details of the recipient, both the organization as well as natural persons. Now, I think insofar as these maintenance of structured digital database is concerned, the most frequent question we've been asked is that, we are doing it through an Excel sheet. Does that constitute compliance? Unfortunately, SEBI has also gotten wind of this Excel sheet, and they're not happy of this details being maintained. They expect it to be maintained digitally, preferably in a software. In fact, SEBI has also been engaging with market players and providers of these softwares, and it expects that the software that the company buys and hosts on its servers is adequately protected, has the necessary systems and balances in place, so as to enable companies to have audit checks, time stamping, exactly as to who had access to what information at what point in time. Well, everyone has recognized that, when you share information outside the organization, these details have to be maintained. That equally applies to sharing of information within the organization. I think this is also some of the aspects we've seen companies have had trouble with, where details of external sharing of information has been maintained, but details of internal sharing of information has not been maintained. Again, this goes back to the principle of need to know basis. When you're used to sharing information with a lot of people on an ongoing basis, this becomes a problematic affair. We've looked at companies revisiting their policies insofar as information sharing is concerned, to try and streamline it a little more, so that only people who are required to have access to a given piece of information are actually brought in on the fold. Obviously, this preservation of information is required for a period of 8 years, and in the event there is an ongoing investigation or an enforcement measure, then this has to be maintained till the completion of the proceedings. Some of the other practical challenges that we've heard from the market that are being encountered is the expectation that this digital database has to be updated on a real-time basis. In fact, some of the certificates which were required to be issued by the compliance officer before the issuance of the circulars by the stock exchange actually expected companies to make an entry in the structured digital database before sharing of the information at the outset. Another issue that we've seen insofar as structured digital database is concerned is that how to maintain the database when information that is being shared is financial information, and there is this whole audit team, tax team, finance team that will have access to information. What we've seen some of the players do, and this may not be 100% compliance, is that they enter a list in the beginning of the exercise, be it the external parties, internal parties. They come up with a comprehensive list, and before the results are being made public, there is a reconciliation exercise to check that any person who was required to be included was not missed out, and any person who was otherwise not having access to information is not captured as part of this. So important to bear some of these aspects in maintaining the digital database is concerned. Another aspect that we've also had discussions on with some of our clients is that mostly the compliance officer is made responsible for maintaining the database. See, unfortunately, a compliance officer may not always have knowledge or be privy to the UPSI within the system. So I think it's important for listed companies to kind of devise a way such that either the compliance officer is kept in the loop, and the relevant persons are also made to make entries in the database under the supervision, or that there is real-time communication happening with the compliance officer for the compliance officer to be able to take that judgment call and make the necessary entries. I think similarly, the stock exchanges have also issued circulars recently to kind of provide standard operating process insofar as maintenance of structured digital database is concerned. They have also helpfully provided certain FAQs about UPSI and what are the kind of details that structured digital database has to contain. There is also now going to be an ongoing compliance certification requirement where the timeline for the December quarter is January 21st of the coming year. It also specified that exchanges have the right to inspect the structured digital database of listed companies on a one-day notice. In fact, these inspections have happened. And in fact, the representatives of these stock exchanges have done a deep dive into the quality of the structured digital database, the manner in which it's protected with audit trails and time stamping, who all have access to that, and what is the quality of the entries that is being made, whether it's being updated on a real-time basis or once every quarter, how have companies gone about doing it. And I think insofar as the whole structured digital database is concerned, there has been a significant time lag between SEBI notifying these requirements and SEBI coming up with these requirements to the stock exchanges. I think the regulator has appreciated that market is going to take a bit of time to come to terms with these new requirements. And it is only now that the exchanges have come up with these compliance certificate requirements and these clarifications on standard operating procedures. Another consequence of this is that if any company has been found to be non-compliant with the whole structured digital database requirement, then on the page where your details are disclosed on the stock exchange website, it will be disclosed that you are not compliant as an entity with the structured digital database. And this disclaimer will remain till the time a new assessment has taken place and you have been found to be compliant with these requirements. I think now it'll be good to just kind of delve into the whole responsibility of the management and board insofar as this whole framework is concerned. First and foremost, the management is responsible for the adoption of all the relevant code of conducts and policies under the insider trading framework. Very quickly, this is the PIT code of conduct, your fair disclosure code, which also includes your legitimate purpose policy. I think a lot of companies do not pay adequate attention or time or deliberate upon what exactly they want to provide as part of their legitimate purpose policy, whereas we've seen some of the companies drafted very, very well, which kind of makes it robust and broad enough to set certain principles which the board will bear in mind while making a decision whether or not information ought or ought not to be shared and whether that's capable of being justified as legitimate purpose. Similarly, there is also a lot of thought process which goes into setting out the policy for inquiry into leak or suspected leak of UPSI, whether every aspect needs to be investigated, or would it be that you make a determination that only XYZ kind of matters ought to be investigated. In addition to that, another important responsibility for the board and management is to ensure that identification of the designated person is happening in line with what the law expects, and obviously in discussion with the compliance officer, and there is a reassessment of this determination on an ongoing basis to see that, you know, if either someone else is required to be identified as a designated person or no longer required to be identified as a designated person. Structured digital database, like we just discussed, is another important compliance aspect insofar as responsibility of the board and management is concerned. The audit committee is in fact required to review compliance with this whole insider trading framework and institutional mechanism at least once a year. The management is also responsible for ensuring that, you know, there is no retaliation against employees that kind of blow the whistle on aspects pertaining to the listed company. Another thing which we believe that management and the board should spend their resources and time on is to ensure that there is adequate training happening insofar as employees and designated personnel are concerned, and that training happens on an ongoing basis. I think only through discussions and deliberations are we able to communicate the message as to why it's important to be mindful of this framework and what are the risks that you take on when this doesn't happen. I think another practice that kind of needs a relook is that oftentimes we see that, the management and the compliance functions don't work together, but are kind of working independently. And in terms of assessment as to when information has taken the color of UPSI, or what are the kind of disclosures which is being put out, what is it that you want to emphasize on what is it that you don't want to draw too much attention on. I think companies have done a lot better when there has been a cohesion between the compliance function and investor relations team and the management, as opposed to when all these functions are working independently. And especially in so far as ensuring accuracy of disclosures or identification of UPSI or enforcement of corresponding checks and balances is concerned, we believe is an important avenue for the management and the compliance function to kind of cooperate and work together. Separately, from a whole MD CEO perspective, they are expected to put internal controls to prevent insider trading, and some of these internal controls are, of course, to ensure that the confidentiality of UPSI is being maintained and there is no inadvertent leakage. Then to also kind of ensure that details of the persons having access to UPSI is being maintained. You sign confidentiality arrangements or agreements with those persons. To also ensure that there is some kind of periodic assessment or reviews which are happening in so far as these aspects are concerned, and we can perhaps see if internal audit can be brought in to undertake this review function. I think we've seen some of the listed companies do that, and it's really helped them improve their compliance standard. Coming now quickly to the role of the compliance officer, as the slide quickly shows. One is, of course, the trading window closure, then coverage of designated persons, periodic reports to the audit and the board, and obviously pre-clearance of trades. Coming quickly to the offenses. I appreciate we're running out of time, so I'm just going to run through these slides a little more quickly, and then we'll quickly take the questions. Like Mr. Vasani and I were pointing out, quickly, the offenses under insider trading not just include trading while in possession of UPSI, but also communication. Scope of trading includes pledging, so any inadvertent pledge while in possession of UPSI will also get categorized as insider trading. Lastly, trading through discretionary portfolio management, where you don't have any control over the trading decision or the timing of the trades, is not a recognized exception to compliance with the insider trading framework. So let's say if you've engaged a discretionary portfolio manager and not put your script in the restricted list, and he ends up doing trades in those scripts, you will be held liable if you had access to information at that point in time. So just be mindful of that. We've seen quite a bit of non-compliances and breaches happening on this front, despite this guidance to HDFC Bank having been in place since 2016. You would have seen renowned listed companies making stock exchange intimation, that their independent director inadvertently traded through a discretionary portfolio management arrangement, and which caused non-compliance with the requirement. Similarly, communication is also an offense. To the next slide, and insofar as you being a connected person, the onus is on you to demonstrate that you did not have access to UPSI. In all other cases, it is on SEBI. I think another landmark judgment that Mr. Vasani was referring to, where the Supreme Court came up with some interesting jurisprudence, is that although direct evidence is very, very rare in insider trading offenses, the regulator is expected to appreciate facts, and merely proving or presuming someone to be insiders on the basis of circumstantial evidence is not a fair practice. And in fact, the onus is, the expectation from SEBI is that SEBI has to demonstrate communication of UPSI based on cogent evidence and materials. Merely a presumption without looking into the facts will not be considered as satisfactory. So obviously there will be a bit of changes to how SEBI approaches its enforcement of insider trading cases going forward based on this. Very quickly then jumping into the best practices, do's and don'ts. We've already dealt with this, so I'm just going to leave it here and then open the floor for questions. I think Mr. Vasani, this is fairly straightforward what we put out, and I think we can take questions now.
There are quite a few questions. In fact, there are quite a few questions. Can a relative of statutory auditor purchase shares in a company as it leads to insider trading? So I suppose this is one area where I think I would tell Rutu, but I would imagine that the principle laid down by Supreme Court in that Balram case would apply. Balram Garg case will apply that you know it can't be presumed that there's a company does not create a deeming fiction in laws that the communication would have happened between the statutory auditor and the relative of statutory auditor with regard to UPSI. And Balram Garg case may be helpful to the relative of the auditor or to the auditor that I have not communicated anything. If he has purchased it, he may be a connected person. Will he be regarded as connected person, Ritu?
Yes, sir, I think, yeah, sir. So if a statutory auditor personnel who has access to information, if their immediate relatives were to trade, then very likely that SEBI will come after them for a charge of insider trading. And I guess based on facts or, you know, the financial independence or, you know, no correlation between the person having access to information or taking trading decisions on behalf of the relative, those aspects will have to be considered to see if the charge can be then defended.
Yeah, but Balram Garg case also will come to the rescue that, you know, you can argue out that, okay, he was related to me, but there was no communication of UPSI.
Yeah, but sir, you know, there it was on the basis of facts that there was in fact a separation,
Yes.
you know, not just from a financial perspective, but even on a relationship basis. So there it worked in their favor.
Here, relative of a auditor, okay, but you know it depends. It's a very fact specific. You can't answer that.
But yes, if the question is, can it lead to insider trading? Yes, it can. So obviously, it'll be driven by facts and how well you are able to defend your case.
Then anonymous attendee. There's no name here. Earlier was from Jai Goyal, but there is anonymous attendee, so whistleblower. When a DP exercises so by taking financial assistance, can the DP create a pledge on such shares after exercising the option? Further, can a DP release the pledge within the period of 6 months?
Yeah, see, that is a contra-trade issue. And in fact, these are the kind of questions we've repeatedly dealt with. Issue is, of course, you can take financial assistance. What happens is only the first immediate transaction that you undertake once you receive the ESOP shares is exempt from contra-trade restriction. So for instance, let's say today you receive the shares on exercise of ESOP. You are either allowed to immediately sell those shares or create a pledge on those shares. But if you want to release that pledge within a period of 6 months, you will be hit by the whole contra-trade requirement.
Then there's a next question again from Nupur Gupta. The requirement of compliance certificates does not arise from the PIT regulation. Then how are these circulars of stock exchange requiring entities to obtain compliance certificates binding on the companies?
See, in addition to having the power to frame regulations, the regulator also has the power to come up with all such other mechanisms. And even the stock exchanges are considered to be the first line of regulators insofar as listed entities are concerned. So while the circular does not say so, our interaction with the stock exchanges and you know the market in general has revealed that these requirements have been introduced post instructions and mandate from SEBI, and this is very much within the purview of the insider trading framework.
Then the next question from again Nupur Gupta. PIT regulations require companies to record nature of UPSI and not the actual UPSI. How will it be ensured that the STT compliance certificate that all the UPSIs have been captured in the database?
I think you have to read it holistically with the regulation as to what the requirement is. You only have to record what is the nature of UPSI and not the exact details of the underlying UPSI. And insofar as our interactions with the companies that have undergone an inspection, this was not an issue. In fact, the entities that only maintained the nature of UPSI and not the exact details did not face any issue. But happy to hear from the floor if anyone's experience has been different.
Then there's the last question from Jayesh Shah. Invocation stroke revocation of the pledge within 6 months with time, would it consider as a contra trade?
So if the same person that has created the pledge is also revoking the pledge, then yes. But let's say invocation of pledge happens at the level of the lender, where you don't have any control as the pledger. So that I suspect is a consideration for the lender. But yes, if you've created the pledge, you want to release the pledge within a period of 6 months, that would constitute a contra trade.
So I think we have dealt with all the questions.
No,
now.
sir, I think there are a few
there
more.
are two more questions.
I'll just
Oh,
read out the next one. Dinesh Ladva has asked that SDD requirement applies to companies which are only debt listed company. What about only debt listed company which are in default and resolution processes going on? Whether SDD applies to be complied with? Yes, SDD requirements apply equally. In fact, you may just want to take a look at the circulars which have been issued by the stock exchanges. There was some FAQ regarding insolvency process. I think it equally applies to them. So there is really no exemption to such companies. It applies equally to only debt listed companies as well. Commercial papers, yes, it's an interesting question and a valid question. I don't think commercial papers, I think this is something we'll have to look at. This is no straightforward answer to this. It's reasonable to expect that this should not apply, but I guess a deeper assessment would be required.
So if there are no more questions, then I request Manoj Sunawala to propose a vote of thanks, because we're already running out of time.
Yes, thank you, Bharat bhai. Before I propose a vote of thanks, let me first apologize that both the speakers, because they could not get proper or a sufficient time to justify such a complex subject or complex topic. And also to apologize delegates, because they could not get a sufficient time to understand or get further details what they would like to expect from the speakers. Going forward, I propose a hearty vote of thanks, first on behalf of my personal basis and on behalf of my Legal Affairs Committee, where I am a co-chairman. I extend my hearty vote of thanks to Bombay Chamber, who has provided this platform to us for conducting this webinar, I would rather. Then I would certainly propose a hearty vote of thanks to Mr. Bharat Vasani, who has made all these efforts to put before us this entire topic and the speakers. I also thank Rutu Gandhi, madam, for giving us their thoughts and experiences, sharing their experiences and minute details how things works out in a practical life, and how the regulators, they bounce on us in certain matters, and how you can safely presume or safely defend yourself. So thank you, Rutu ma'am, for giving us the insights for the same. Then I would like to extend our thanks to our sponsor BASF Limited for giving us the facility, giving us the sponsorship. Then I would like to thank our committee, entire committee, including Ms. Atreyi Mukherjee, who delivered a welcome speech. And none other means I would also like to thank Mr. Khosla and his team, and especially Mr. Ganesh, who has relentlessly worked hard to put before us this entire webinar. And also none other than, none less than you people, all delegates, I would like to thank, because of you, we are here. So thank you all. Bharat bhai, shall we end this webinar, or do we have anything else to say?
Mr. Manoj, just from my side as well, thank you, Mr. Vasani, thank you, Ritu Gandhi as well, for this excellent presentation. I think this topic is ever needs to be further evaluated on a case-by-case basis. I think the regulator its task on the insider trading part, and we as compliance officers and councils need to be further vigilant to spread this message across the organization, especially within the management, and further strengthen our internal controls. So thank you, I think from our side, from BSF as well.
Thank you, Mr. Kamath. Thank you for sponsoring it. And according to me, this is the most important topic of the boardroom discussions just now. Because reputational risk, apart from financial risk, where the penalty can go as high as 25 crores, the reputational risks are very, very high. You know, and it perpetually debars you in certain appointments once you are convicted of insider trading violations. So regulatory and reputational risks are so high that I think nobody has a choice but to adopt a very robust compliance system to ensure that there are no infractions. You know, invariably, sometimes out of sheer ignorance, people do mistakes and they trade during closure of trading window, and people like you and me then have to go through the rigmarole of dealing with the situation with SEBI. And SEBI has, I think, now adopted a zero tolerance to any infractions, that policy of zero tolerance. So thank you all, and we will have a next webinar. We will announce it, and thank you so much for such a wonderful support and being such a nice audience. Thank you.
Thank you very much.
Thank you, everyone. Thank you
Have a
for
nice
having
evening.
us.
Bye-bye.
Bye.